Be a little bit of a surprise as the slides come up, but we should be fine. So, first of all, how was the session yesterday evening on reading the compromise? Was that useful? Did it give you kind of an insight into how to really break this down? Obviously, we had to kind of fly over it yesterday, but hopefully having a bit more focused time on it has been good. And then this morning, your lecture was on the law itself, on the sources of international law. Is that correct? Or yes, cool. So we're good. Okay, so we now have a little bit more of a grounding in the law and a little bit more of a grounding in how to actually approach the compromise and understand what it does. So today's lecture, I kind of want to touch on the actual mechanics of the legal argument portion of the Jessup. So less so about how you craft a legal argument, but more about actually how you write this memorial, how you then turn that into oral submissions, and then how you stand in front of a bench of judges and plead that for 45 minutes, which probably sounds impossible to you now. I remember when I started mooting that the idea that I could stand and talk for, about 25 minutes on your own on these sorts of issues, I seemed out with the realms of possibility. But you can absolutely, there are ways you can practice it and you can get better at it, and once you have that skill, it's sort of so much easier to get by in these kinds of situations. I mean, everyone quite rightly stresses how useful the Jessup is for any kind of legal practice beyond your law degree, and it's absolutely true. Once you can kind of write long-form legal arguments that are incredibly detailed and but also concise and easy to read, it really puts you kind of massively far ahead of anyone else in your law school. So I'm gonna have to do some weird pointing system. This is great. So just to sort of recap what we discussed yesterday, we obviously talked about the importance of IRAC, that the IRAC structure is the heart of at least writing the memorials. It's the easiest way to avoid problems with the word count, and it is the way that it also requires that you write your memorials as well. So you'll get a better score if it's written in this structure. So as we discussed, as you're starting to think about legal arguments, it can help to break the page up into 4 pieces and make sure that you try and follow this kind of blocked out structure. So the issue is always the actual point in dispute. The rules are just the general rules that govern this issue, but there's no legal argumentation there, or no no attaching that to the actual facts of the case. You just want to talk about what the law is on its own. Although we can talk about how, when you're actually writing the memorial, the rule section may be ordered differently depending on whether you're applicant and respondent and what law you want to rely on, but we'll touch on that later. The application is where you actually apply things to the facts, and that will be the focus of tomorrow's class because it is so important. It's essentially the application is the whole of the Jessup. It's the point where you learn how to make a legal argument that can beat your opponent, even though you both have the same tools at your disposal, you both have the same law, you both have the same facts. And the conclusion is essentially based on what your submissions dictate. That's the point that you eventually have to reach at the end of your argument. And we also discussed how to identify relevant issues from the submissions in the compromise, and how to make sure that we're paying attention to our opponent as we go through these things. So we'll go to the next slide. So today's lecture, we're just going to look at the actual mechanics of it, writing the memorial, then translating that into oral arguments, how oral arguments are structured, how to talk to judges, the kind of judges that you'll get, the kind of questioning you'll get from judges, and then an overall picture of how the scoring works in the competition and how the competition progresses on the basis of this work over the year. So to start off with another little arrow diagram, there are official Jessup rules that need to be followed. They change every year. I mean, they don't change drastically, but they are altered every year. So it's always worth looking at them, and your coaches will look at these. And you can find the rules if you go on the Jessup website here. As you can see, there's the Jessup tab, and the 4th bar down is Jessup rules. And then you get to this page, and there's a link there for PDF. And that's what the official Jessup rules look like. They are 40-something pages long, 48 pages long. And they govern everything from how judges are selected, how national rounds are administered, how a team is put together, how that team registers itself. So not all of it will be relevant to you, but just so you know, this is where all the rules are. And if we go to the next page, there's also, each national round will have its own rules. I had a look at the Ukrainian ones last night, and they don't seem to change the official rules at all, but some national rounds have more, have different ways of putting their rounds together from the international rounds. I think here mainly it just replaces who the contact information is for the national administrator. So the memorial, the content of the memorial is laid out in section 6 of the Jessup rules. And there are, as you can see here, 9 parts that the memorial has to contain. And it's to contain no more than this. So sometimes people will put things like tables of abbreviations. The rules say not to do that at all. If we go to the next slide, only 4 of these are actually work that you have to do. The cover page is, I mean, there are rules for how the cover page is set out, but it doesn't involve any work. It's just making sure that your team name is there, the name of the case is there. The table of contents you can auto-generate with Word from how you set your memorial out, so that doesn't involve any work. The index of authorities is quite time-consuming. You'll have to have someone sit and comb through the entire memorial to pull all the authorities and order them. So that takes work, but it's not work on its own. It's these 3 parts: statement of facts, summary of pleadings, and the pleadings themselves are the actual argument of the Jessup itself. I'm certain somewhere in the ILSA website they publish example memorials or draft or the award-winning memorials every year in the international rounds. The top scoring memorials I think are published. They should be published in the ILSA journal, but I really struggled to find them. I found them before, but I was looking before this class and I couldn't find them anywhere. But if you can track down one of the memorials, or even if your coaches have previous years of your university competing, it can be useful just to look at it. Firstly, to see what a memorial looks like, and then also that, I mean, the statement of jurisdiction never really changes. You just have to change the names of the 2 parties, the countries for that year. And so yeah, and the cover page is nominally the same. So it can be good to have a sort of award-winning memorial to check your own work against. In terms of the other ones, the questions presented is really just it's just the submissions, or the submissions and the sub-submissions, and the conclusion prayer for relief is just your submissions at the end, rephrased as a request for what you want the judge to do, or the court to do. So those don't involve any work. It's mainly the statement of facts, summary of pleadings, and the pleadings that we'll be focusing on today. So all in all, that's around 12,000 words worth of work. The statement of facts is 1,200, the summary of pleadings is 700, and the substantive pleadings are 9,500. The order that you would write these would be the substantive pleadings first. I think that should be quite clear. So the substantive pleadings are your actual argument. 9,500 words is not a lot. I don't know if any of you have written something of that length, but when you have to deal with 4 submissions in that space, each of which have multiple sub-submissions, you're going to be pushing up against that word limit. And it's something to keep in mind as you're dividing the work and as you start to write the memorial as the year goes on. It's worth having everyone make sure that they're not inflating their own section of the memorial to ridiculous length. The worst thing that can happen is that you hit December and you need to start pulling the memorial together, and somebody in the team has a 6,000 word part on just their submission. It's also worth thinking, and we'll focus on this a little bit more in both the oral pleadings, but also in some of the road mapping discussion. It's worth starting to think, as you're getting the memorials together, about what the most important parts of the case are. Normally the case is not, all 4 submissions are not necessarily huge issues. So, for example, you might have one submission that is on a very broad policy, but it's on an entire government policy of, so for example, in the case that you have for this week, the first part is on the drone strikes in general, and the second part is on a very specific event. So you need to think about how you want to divide those 9,500 words up. You might not want to give equal shares to each submission. Some submissions might be more detailed. Some submissions might lay out legal tests that later submissions will be able to rely on, so it's easier to just give the focus to that submission. Some submissions may have more parts to them. Often the first submission may have some kind of evidentiary admissibility or some question of jurisdiction or something that needs to be dealt with for the entire case to proceed before that submission can even start. Don't try and guess this when you first pick the compromise up. This is something that you'll learn as you start to read it, as you start to work out how complex each legal argument is. It can be worth starting to think, okay, we can give a little bit more to submission 3 and a little bit less to submission 4. In my experience, there's normally been 2 big submissions and 2 smaller submissions. And they're normally divided 1 and 2 and 3 and 4, where one will be a sort of large issue and then one will be quite specific. And you want to give more focus to the large submissions, at least in your written argumentation. We'll talk later about how that might be different at the oral rounds. But for the written argumentation, you need to give the space that the submission deserves. So once you have the substantive pleadings together, and we'll go into exactly how you put that together, the summary of pleadings and the statement of facts are the last sort of, you'll do them once the substantive pleadings have been put together and probably are starting to be edited. Then you're going to want to work on these 2. The statement of facts, if it's not clear, obviously the compromise is much more than 1,200 words. So you need to work out how to summarize the important facts for your argument. So the statement of facts will be different for the applicant and the respondent because you'll want to be highlighting different facts in your statement of facts. There may be facts that the other team won't use. There may be, not that you should ignore facts, but there may be facts that are not important to the argument. There may be things that need to be given more explanation. For example, if one state is arguing that, I don't know, a certain policy occurred because of ethnic difference, then they would need to explain the ethnic minority more than the other side might have to if they don't think that's important. So one team might need to enumerate in the statement of facts exactly how the ethnic minority are different from the majority population, whereas if the other team thinks that, you know, the riots occurred just because there was a criminal activity, then they don't need to spend 500 words setting that out. They can just say there are an ethnic minority and carry on. I mean, don't stress about this. This is the thing that once you've written the arguments, it's just a matter of kind of setting out the story as your side understands it. That's maybe even a better way to think about it. Again, within the Jessup universe, you are the legal advisor and the legal representative of the state. So you need to set out what your state believes the facts to be, and what facts your state thinks are most important. And the states won't necessarily agree on that. Again, you can't lie, you can't change the compromise, you can't make up facts, but the story that you want to tell will probably be different from your opponent. The summary of pleadings is essentially just you just summarize what the kind of road mapping is of your argument. So that shouldn't take too much work, but again, it will depend on how you've structured your pleadings, will depend on how the summary turns out. So it's worth bearing in mind that you only have 700 words to summarize the pleadings, and that the road mapping shouldn't be too detailed, because that can cause problems later on. When we discuss road mapping, that might become clearer. The other point is that the moros must be submitted by 5 p.m. Eastern time. That's midnight here. It's also midnight in Finland. That's the only reason I remember that. So you can sit in the library until midnight hammering at the thing and send it off. The date that they're submitted will change depending on when the national and international rounds land. So that will be announced sometime. I think the schedule is normally released in September, so you'll get a sense of when the work is. It's worth saying at this point, because I don't think there's a slide on it, we haven't really talked about how much work the Jessup is. And this isn't to put you off. I mean, it's absolutely the best thing you can do in law school. But the Jessup will take over your life. I mean, the jokes are, they're jokes, but they have an element of truth. So when you start researching it, I mean, you might only be spending a few hours a night and then meeting once, twice a week. It might not be too heavy. As you get closer to the memorial deadline, you'll maybe start meeting 2-3 times a week. Normally what happens is that the memorials are due in early January. So there's normally, at least the way that we've always run it in Helsinki, we've required that there's some form of a draft memorial, even if it's not polished or edited. There's some form of a draft memorial in our shared Google Drive by Christmas. And then everyone has a week off, Christmas to New Year. And then, and particularly in Helsinki, we were often living in different countries. And then we would all convene back in Finland around the 3rd, 4th of January. That gives you about a week to pull the memorial together. The memorial was normally due around the 9th, the 11th of January. That week, you will be in the library from 9 a.m. till they kick you out of the library. And then you will decamp to somebody's house, you'll work there till 3 in the morning, you'll barely sleep. It is a huge time commitment. And the oral rounds will be even more of a time commitment, we'll get to that. But I do think that you'll instinctively learn how to balance your workload when you do the Jessup. You'll realize how much work needs to be done against your other classes, and you will be able to navigate these. It can be useful when the team first starts out to sit down and draw up a planner if there are exam periods or periods where people have essays due or other commitments. It can be useful to work these out, or even holiday times. That was something that some teams have drawn up where they've said, okay, I'm going on holiday for a week, so I will have a part done, and then I can leave, and then you can work on that while I'm away. But it is possible to juggle all these things, and actually it's a useful skill that mooting will teach you, is how to balance your workload, how to have one big piece of work that's subsuming all of your time and still be able to keep all the other plates spinning, still be able to pass your other classes, do your reading, attend most lectures, maybe you'll skip 1 or 2, but you will learn the skill of how to balance this, and that's incredibly useful regardless of whether you go into practicing or being a researcher. Being able to balance different kinds of work commitments is a really great skill to learn. But just a fair warning, the memorial will torture everything up to the Christmas period for you, and then you'll have no rest in the new year before the year starts. So it's just worth taking that into consideration. But don't let it put you off. I mean, honestly, it's 550 people have done it every year for 58, or 550 teams this year. So however many thousands of people have done it for 58 years now. So just, you can survive. I'm living proof that you can survive. So, yeah. So the score sheets. So when you submit the memorial, it goes to ILSA's hub, and then they take their pool of judges and they spit the memorials out. You're going to get this, as you can see on the ILSA website. I think I actually just Googled Jessup memorial score sheet and it came up. So, I mean, it's not even, you don't need to go and trawl through the ILSA website for this. Each judge is given a bench memorandum. So there's the compromis, and then the judges will also be given, I looked at the one for last year and it was about 40 pages long, a 40-page document of the relevant law and some of the relevant factual issues that connect to the law in this year's case. So we'll normally give them a sort of statement of what the situation is for each submission and then how the law interacts with that. So in theory, that should harmonize the grading, or it should mean that the judges understand what's going on in the case. And also the oral round judges will also have that. So every judge that you see should have the bench memorandum, unless of course, like me, if they coach teams while they're judging, then often they're not allowed access to the bench memo because that breaks the rules of the game. So those judges are more wild. They'll just ask questions that they think are interesting. That can be problematic. We'll get to that later. But there is a score. There is not a score sheet, a cheat sheet that should tell the judges what they're looking out for. Now, in practice, that's never as comprehensive as what everyone around the world will be able to produce, all the students. All the students working on this for 5 months will find arguments and sources and impressive things that are not there. So there is a slight element that the bench memorandum is not exhaustive, and that it depends on what judge you get, depends on how kind of much they understand the issues and the complexity of it. That's one of the things you just have to sort of go with in the Jessup. We don't have robot judges. There's no way to make this fair. So it's always kind of subjective by the people that grade you. So the memorial scores are graded on a scale of 50 to 100. Unlike the oral round, which we'll see the score sheet for later, here the judges are just asked to give a score. You can't really see, but at the top it just says total memorial score, and adds this grade from poor to perfect. And you can leave comments, but it doesn't require them to do any kind of breakdown of how they've got to the grade. They just need to read through it and say whether it's perfect, excellent, very good, good, and grade on that. And then go to the next slide. There is an optional breakdown at the bottom of facts, analysis, research, organization, and grammar. These are all weighted the same, so they're all 10 to 20. And as I said, it's not binding. So a judge might, say that the grammar is poor, but still decide to give more points if they think that it was made up elsewhere. Or, for example, the legal the legal content might be great, but if the grammar is terrible, then the judge won't understand it and they'll mark it much lower. This is not something to worry about. It's just something to be aware of, that while there are things that are suggested to the judges that they should look out for, the memorial score is much more of a kind of overall quality. And that's something worth thinking about when you get to the stage of editing the memorial together, that it's the grade of the entire memorial. The entire memorial needs to look good rather than necessarily specific points. They're not going through and ticking a box, oh, you've got this case, great. It's more about the overall image of how you put your case together. So it's sent to 4 judges. The judge that is furthest from the average will have his score removed, and then the other 3 judges are added up together. These are then used in the oral rounds, and we'll get to how that works later on. But yeah, just to say that there is some margin of error, that if one judge thinks you're brilliant and you're not, or thinks you're terrible and you're not, then they will have their score removed. So you should be close to the regular bounding. From what I've seen, the scores normally don't vary that much in terms of for each memorial. It's unlikely that you'd have someone giving 70 and someone giving 50. Normally the judges are quite consistent, but there can be variation just by the very nature of how it's graded. If we can go on. Penalties. This is also in the rules. It's in chapter 11, I believe. There's a number of formal penalties or formal requirements for how the memorial must be set out. So it must use the correct font, it must be the correct font size, there must be the correct margins, a whole bunch of other boring things which you can read in the rules. I'm not going to show you the correct font. That's ridiculous, but you can see how this breaks down into different penalty points. Plagiarism can cost you up to half your memorial score. Anonymity is a big thing in the Jessup. So you can't let anyone know from within your memorial which university you're from. And it's the same at the oral round. You can't tell anyone what university you're from. So, I mean, I don't think I've never known anyone to do this, but don't write something like, as our professor such and such said, or don't cite, well, I don't know what another example would be. Yeah, don't write somewhere that identifying your university. I don't even know how you would breach that rule, but you can be disqualified if you do it. In terms of other ones, so there are penalties for, if your summary of pleadings goes over, you lose 2 points. If your statement of facts goes over, you lose 2 points. The No, it's okay. There's different ones for the word count of the pleadings themselves. Failure to remove track changes can take points off. And these penalties are taken off of every judge's score. So it's not that you will lose 2 points, you'll lose 6. Helsinki's never had a problem with this, so I can't talk to how, but I've never done the formatting. I have to say we gave that to someone else. Someone else on the team, I'm not saying we outsourced it, I just mean someone else in the team handled this. Normally it's easier if there are some things you can do early on, like for example, making sure everyone is using the right font, everyone is using the right font size, that there's no weird line spacing. If you can make sure that everyone is writing like that already, then it'll make it easier when you pull it together. But normally it's easiest just to give one person the job of this formatting, and they just sit with the master document and they do it all themselves. And as long as you can trust that person, that's the easiest way to avoid penalties. If you all try and do it separately, it becomes too complicated. But yeah, we've never had a problem with it, but I think they can be quite, the judges can take quite a lot of care in making sure that all these requirements are met. So just be aware that it can cost you quite a lot. I mean, it can cost you a whole band. If you make 1 or 2 mistakes, or for example, if you go, let's see, if you go just 300 words over, that's 12 points off every judge score. That's a drop from very good to good, or from excellent to very good. So it can be a big difference. So just worth keeping all of this in mind. We can now go to the next slide. Is there anything else? I feel like there's something else I wanted to say about scoring. No, we'll come back to that. So you have all these arguments, and what you need to work out is how to get them all into 9,500 words and have it be readable from start to finish and be clear to the judge what you're saying. The way that he also suggests you do this is through something called road mapping. So road mapping identifies the different levels of the argument, conceptual levels of the argument, that come down to each individual IRAC section. And this will be mirrored by the headings that you give in your memorial. So you'll have 4 main headings, which are just your submissions, just the text of submissions, 1, 2, 3, and 4, and they're copy-pasted. You then want to break these down into A, B, C, D, however many subunits there are, and we'll talk about how we conceptualize those subunits on the next slide. But from those larger groups, you then have the individual arguments, which are 1 and 2. As I think it's frowned upon to go below 3 sublevels. Normally they see that as being overly complicated. And you will find yourself, particularly in December and January when you're editing it, arguing and agonizing over how to divide this. How do I get this argument in before this argument so that this can make sense and I can cut these words out? And it's a nightmare, and there's no right answer of how you do it. It depends on what your argument is, how you've understood the arguments fitting together. There are obviously ways that are better and worse, but to some extent, I can't just give you an answer for how to do this every time. And it's something that you'll find also in terms of which arguments you're seeking to place emphasis on, to give more space to, will depend on how you roadmap this. So if we can... oh yeah. So it's not only your headings, but you also want to write the roadmap into the text itself. So for example, if your first heading is the first submission, you will then have a paragraph that says, so like, for example, in this one, this is made up, this doesn't mean anything. The actions of the respondent violate international human rights law, brackets A, and international humanitarian law, brackets B. Accordingly, they're required to pay compensation, brackets C. And then you would have heading A, which would say the actions violate international human rights law, and then you would have all the human rights arguments in there as divided sections. So there would be, regardless of the respondent's reservations to the ICCPR, it applies, brackets 1. Accordingly, its actions have violated the ICCPR, brackets 2. And then each of these, so 1, 2, 3, 4, 5, would be individual IRAC arguments. You would then be able to fit your issue, rule, application, conclusion in there. If we go to the next slide, I think this has... So the question is how you divide this, how you sort the individual IRAC pieces that you have together, how you sort them into a sort of pyramid scheme. So here are a couple of ways that I think make sense to think about it. One is to think about if there are factual distinctions that require to be treated separately. So, for example, if the relevant action has affected two different groups with different violations of international law for each group, then you might want to say the treatment of this group is in violation of international law, brackets A, the treatment of this group is in violation, brackets B. Or it might be something like a temporal thing. So you might want to say that the actions before a certain date violate these rules, and then after a certain date they violate these rules if there's some kind of change. Normally temporal ones are actually better to be individual IRAC arguments, I think, now that I'm saying that out loud. It normally makes more sense to say that there's a certain rule that is violated and you explain the different events that in which it was violated. But I don't want to say that as an exhaustive claim because each case is different and sometimes the case will require you to separate different time periods out. Like I think, for example, in our case, we had an annexation of territory, and that affected some of the legal claims later down the submission. So we had a subheading that was about what happens if the annexation has been successful after this date. The legal rules are all different. So it's just worth thinking about that. Another one is to think about legal groups. So that's the example that we saw before. If it's international human rights law, humanitarian law, just international law in general, the UN Charter, well, the UN Charter is quite specific, but sort of regimes of law that you want to deal with, you might want to have these separated out separately. And the third one would be steps in the claim. So if your submission has a general admissibility issue, then a legal issue, and then some kind of remedy, then you also want to divide these into 3 sections. But you will be revising these as you go through the year. The main thing to keep in mind is that, you don't want it to be overly broad because then it doesn't tell. You have to imagine that the judge is the one who sat reading this. They've never met you, they've never spoken to you about the case, and they're reading your argument for the first time. You need to lay out exactly how you see the argument progressing. Because if you get the roadmap right, then the arguments are much easier to follow. Then it is just a box-ticking exercise. You've told them that there are these events that violate this regime of law, and then you've laid out the bits of the law that are violated, and then you go through and explain how they're violated. And that's much easier for a judge to follow than if you just throw loads of legal tests at them kind of in an unorganized way. So just try and make sure that you're getting a good balance between being specific enough that you're leading the judge correctly through the structure of your argument, but that it's not so specific that it doesn't really do anything. So you're not just saying, let's talk about one event and then just have one legal rule. That doesn't really help anyone. So it's just about trying to make your conceptualization of the case really clear. Once you then get to December and January and you're editing and you have word count problems, you then may need to revise them again as certain arguments become smaller, certain arguments become bigger, certain arguments will move. You may end up revising these kind of up until the point when you are actually editing the memorial together in January. Don't worry about that. It's just something to think about that, this does take kind of experimentation and time. So I was going to run through a quick example. So we obviously have our one from yesterday, from submission 1. And if we go to the next slide, I think I have. So these were kind of some of the issues that we came up with. There's the international law governing drone strikes and the available remedies open to the court. Can you go to the next slide quickly? And then, so just in a couple of minutes, how do you guys think you might break this case up? You also have had yesterday afternoon working on it. How would you go about dividing this case? if we were road mapping it? I mean, what kind of issues do you see here? Or do you want a couple of minutes to discuss? Would that be easier if you want to discuss in groups and then we can go round? Does anyone have a suggestion? I mean, so what do we, so if we go back to the last slide, sorry, can we go back to the last slide quickly? Oh, you did, sorry, my apologies. So we have two main issues as I understand it, and now you're going to see my terrible handwriting. That's not going to show up. So we have the drone strikes, and we have the remedies. Capitals to small, that's stupid. So this would at least suggest some sort of division, that we can do this like a mind map. This would at least suggest some sort of division between A and B. Can we go back to the next slide? Sorry, yeah. But then we have these other issues that we've identified. There's the events, there's who has the power. So do you have any ideas for how you think you would go about, or even just from what you were discussing in your groups yesterday, how are you conceptualizing the case right now? What do you understand the main kind of issues to be? Have you talked about this much, or is it still in a... Okay. I mean, it might be easier. Let's not agonize over this. If we go to the next slide, I think I've had an attempt. Oh, next slide. Sorry. Next slide. Here we go. So I had an attempt at how I think I would divide it. I don't know if this makes sense. Please don't copy this. It's definitely wrong. Okay. I've read the case twice. I am not like an expert in this. But this was a general way. I sort of agonized over this, and this is why I'm telling you not to copy it, because I think it might be wrong, but this was one way I came up with of dealing with it. So the first question would be that so this is, sorry, taking the applicant's submission, we should say. This is applicant submission 1. The respondent would not necessarily lay the argument out exactly the same. As I see it, there are 3 issues. The first is whether they're standing at all to bring the claim on behalf of both the events in Applia and Respia, because there's a question of how the legal rules operate in both places. They might be different, which is why, to now show you my neuroses, I wonder if this should be split differently, because not all of these rules would apply if it occurred on Respian territory. So yeah, now I'm doubting myself in front of an audience. This is fun. As you can see, though, what I've attempted to do here is divide it into sort of steps of the claim. So the first would be that there's a general kind of admissibility point about who exactly the state is representing, who exactly the state is arguing on behalf of, and who the sort of object of this case is, whose rights have been violated, who is being killed, essentially. And I suggested that there were 2 points on that, one on diplomatic protection and one on obligations erga omnes. The next section then looks at the drone strikes in general. That's a substantive issue, and it breaks down some of the rules. And again, I'm not an expert in this area of law in particular, so these are not the correct rules. But the strikes violate international humanitarian law, in this case, the Geneva Convention, or Protocol 2 of the Geneva Convention, that the drone strikes violate Article 6 of the ICCPR, that the drone strikes violate the territorial sovereignty of Applia, and the drone strikes violate Article 2.4 of the United Nations Charter, which is the prohibition of the use of force. These are the 2, this is to show you my thinking now, these are the 2 that I'm unsure how to deal with, because they require only to care about the fact that Applia is a different state, whereas the first 2 issues are about the people who are killed, and the question is whether they have standing to bring that claim. So I would now maybe, if I was having another pass at this, now that I've got to talk this out in front of people and show that it's wrong, I would possibly have combined these 2 and these 2 arguments in one submission. So it would have been that the deaths of the individuals have violated international law, begin by showing that there's two different claims of individuals who have to be dealt with, and then the substantive law. And then also say that the drone strikes, having crossed the territory, have violated certain rights that AppPlayer has as a state. And then, of course, the third part is that we have the question of remedies. So that's to just give you an idea. As I said, the law is not correct, and is not comprehensive, and it's not wrong, it's just not comprehensive. As you work through this case through the week, you'll discover layers that we haven't noticed yet, or you'll discover legal arguments or legal tests or legal sources that we haven't started to cover here. And you'll need to work out how to fit all those together in a way that's convincing. But this is just a suggestion of one way that you could approach sort of road mapping the start of the submissions for your own memorials this week. If we go to the next slide. Yes, so best advice for how to actually work as a team to produce the memorial. Write an IRAC. Obviously, when you start out, you're going to be writing just this research point, this case looks like it might be relevant. How does this case intersect with these facts? And that's fine. But once you get to around late October, November, you're actually starting to write arguments. Please write an IRAC as soon as you can. Again, one of the worst things you can find and I had this when I was a coach, that our team, 2 of them had written in IRAC and 2 of them had written in Creek. And we had to decide which one won out, and we had to decide who. And the problem was that the people who'd written in IRAC actually had more work to do. No, they had less work to do, so they had more time to refix their arguments than the other people who still had to do some legal research. So in the end, I think we actually submitted memorials that were not in IRAC, and that cost us. The memorials weren't so good. So the more that you can make sure that everyone is writing in IRAC, and I mentioned before, what can be useful for your team is to set up a Google Drive or a Dropbox or whichever brand you have loyalty to, and be posting stuff every week. Be posting cases, be posting your notes, where your arguments are at, so that everyone can read them before you have a meeting. And if you notice that someone is not sticking to IRAC when they've started writing arguments, you get them to fix it now. You get them to fix it early on, because if you have to deal with that in January, it's like pulling teeth. Like trying to restructure the entire argument is a nightmare. So the earlier you can do this, the easier it makes editing. Try and stick to deadlines within your team. Obviously stick to the big deadline, because that will cost you seriously. But if your team say that you need a draft memorial by Christmas, have a draft memorial by Christmas. Now, I am terrible at sticking to deadlines, so this is a little bit of hypocrisy on my part. And if any of my teams end up seeing this video, they'll probably be laughing about the fact that I've told you to stick to deadlines, because I don't do it at all. But the more that you do that, it just, not only does it mean that the team can clearly map out when you're going to have your work all completed, but it also reduces a lot of the tension between your team. The worst thing is if one person is not sticking to deadlines, everyone will resent them, and it makes everything else harder further down the road. And then the other thing is to make sure that everyone is citing cases correctly as soon as possible. So there is a suggested citation in the Jessup rules in chapter 6, if you can find it. And I would recommend that the earlier that you start writing in that way, it means that you don't have to go through and fix all your footnotes again in December or January. If you can just start doing that as early as possible, it makes everything easier for everyone. When you actually get to the editing stage in January, so you have the draft will probably be 3,000 words over, as it always is. What I would suggest, and the way that we did it when I was a competitor, was we rented a room in the library, or we booked a room out in the library for a week. And the first few days we would work together in twos. So the applicant would work on their memorial to make sure that it was short enough. The respondent would work on their memorial to make sure it was short enough. And then the applicant 1 and 2 would meet with respondent 1 and 2, and they would work through their arguments together to make sure they made sense. We did that for a couple of days to make sure that both memorials were getting shortened and that also they were interacting together. And then we created 2 master documents, and we booked a room that had a projector, and one of us sat in a laptop and projected it on the wall, and we went through the memorial line by line. And it's so time consuming, but we went through it and we made sure that each argument followed the same structure. We made sure that the language was consistent. One of the worst things you can do is to submit a memorial that reads like 5 people's essays, like where someone has written a section and just copy pasted it in, and the next section is written in a totally different style. I don't mean structure, but actually the way of writing. And it also helps with the word count. As you start to do that, you can start to work out a way as a team to write concisely. Obviously, you'll all be writing in your non-native language, so I would try and identify who in your team has the best English skills, and if they can kind of be the guide on that. In my team, I was the native speaker, so that was my job, was editing the language so it all made sense and making sure that it was all consistent, like sort of short sentences, not you overusing words, just kind of making sure that it read as one thing. And the memorial reads more like a single flowing argument than if you sort of judder between different people's work. So what I would say is you do that with one document, you edit through the document, you have that done, let's say 3 days before the memorial's due, then you give that master document to whoever is doing the formatting in your team. They format that document while the rest of you edit through the second memorial, and then you have like a day left to do the rest of the formatting, a final check, send it to your coaches, and then have it submitted. And yeah, obviously because the memorial is not graded, because it's graded as an overall piece, you need to pay real attention to how persuasive it is, how convincing it is, how well written it is. Please make sure that there's not highlighting in it. Our team this year, who I should say I was only coaching from a distance, this was not my fault, they sent something that had a highlighted comment that said, "Find authority," highlighted in yellow, which we only discovered a week after we'd submitted it. And our head coach, Craig, had to go and have a kind of army sergeant shout at them for that. So just avoid mistakes like that. But also, one of the best pieces of advice I was ever given, a lecturer of mine at Glasgow told me that when he starts grading essays for an exam, he starts at a B2, which is like a 70% grade. And he'll read, and if the argument is good, he'll, B1, A5, A4, and then if something happens in the argument that pulls him out of it, back to a B2, if not below. And then he'll start reading again. So it can be useful to make sure that the whole argument is consistently good. It might be better to have a consistently good argument throughout than to have one part that's excellent and one part that's weak. Because if there's one part that's really weak, it's going to make the reviewer, the judge, forget all the good stuff before. It's going to pull them out of the convincingness of your legal argument. I should say the same lecturer also said that he has to regrade the first 2 or 3 papers that he does every year because he'll drink a bottle of wine as he grades the essays, and the first 3 will always be graded too harshly because by the time he gets to the last one, he's kind of drunk and is just giving them all A's because he thinks they're great. I don't know if the judges do that for the Jessup, but so just make sure that your entire argument, the memorial reads as one, that it's nicely edited, that it flows well, that it's well structured. If you can do all of that, then actually the legal content, it's not that it's not important. Obviously, if a judge notices that you've cited the wrong case or you've missed something huge, then that will lose you points. But if the whole memorial looks good, that's probably worth more structurally than if there's a certain argument is well made or if a certain case is there or is properly explained. Move to the next slide. So if we want to take a quick 5-minute break, and then we'll turn into how to move from the kind of written submissions into the oral ones. Does anyone have any questions about the memorials before we move on? Has anyone got Did that all make sense? Was that clear enough? I mean, I think you might have, I guess in your coaching sessions, you might have more of a discussion as you're actually writing them about how to do this. And there is the writing a memorial guide, Scottish R just trips you out. Writing a memorial guide on the White and Case website, and I think also on the Jessup website. Most of that should be there, so if you need to just refresh that, just check through that. But yeah, let's meet back at 15:15 and we'll take on the oral. Yeah. So there's a couple of questions that I got in the break there, just I'll sort of discuss them with the group. One was generally about, is there a way to practice the convincingness of your argument, to get better at writing legal argument? It's hard to say, particularly as a native speaker, I struggle to explain what is or isn't good English sometimes. So it can be hard to explain how you can get better at it when it's sort of your own native language. There are a number of books on legal writing that you can get. I'll try and find the names for them tomorrow because I don't have them to hand. But there are books you can buy that explain sort of some rules you can follow to make your argument better. One of the simplest ones is just making sure that you're not repeating words, that you don't use more words than you need. So if you're saying that something was, I don't know what an example would be. If you're describing a factual situation, you don't need 5 adjectives to describe it, and you can use 1. Just trying to cut words out like that, because it does make it easier to read. And kind of being strict with IRAC can help when you start out, but then there is a need to blend that. You need to make sure that it doesn't just seem like you're saying, here's the problem, here's all the rules that I've read, all the research I've done, here's 40 cases, here are the facts, and this is the conclusion. Like the hardest part of the memorial is to try and blend that smoothly. And we'll talk tomorrow about, when we talk about application, we'll talk about how you learn to use rules to smooth into the application, how you make those kind of seamless. But yeah, one of the things to maybe watch out for is that even though I've told you to treat IRAC like a block structure when you write, that when you actually get down to it, you need to work out how to make it a kind of convincing, smooth argument. But we'll try and talk about that more tomorrow, and I'll see if I can find anything else. The other thing is just to read memorials that have won awards before, and read high quality academic articles, and just see how an academic takes how they take a situation through. So they've identified a problem, they'll tell you what the law is in that problem, and then they'll critique it. It can be useful to read that just to understand just how to make a difficult and complex argument. And again, we'll look at this a little bit more tomorrow when we talk about what it means to make a convincing argument in international law, what the parameters of a convincing legal argument are. There's a number of ways that you can assess arguments to understand how that kind of structure flows. But just it's something, if you just make sure that you're always reading. I mean, and if you read EGIL talk, if you read the European Journal of International Law, those are both like exceptional. The Leiden Journal of International Law is also great. They publish exceptional and quite difficult legal publications, and if you read them, it'll help smooth things out. There was one other question that someone asked, and I've now forgotten what it was. What was your question? Policy, yes, we'll talk about this more tomorrow as well, but one of the questions is how you balance policy with law, particularly if the submission that you have seems difficult to win. So for example, if you're advocating a policy that every other state clearly carries out. Like drone strikes, for example, in fact, is quite a difficult one. Drone strikes is a hard one to argue because we know that lots of countries do drone strikes, and it's difficult to explain why America, the UK, Israel, Germany, I believe, also has drone capabilities, to explain how they're all constantly in violation of international law, and yet a rule exists. We'll focus on this more tomorrow, but one of the ways is to think that a policy argument like that should not be the argument itself, but it should be the conclusion that you're the conclusion, it should be the outcome that your legal argument leads you to that's clearly the right outcome, if that makes sense. So through the legal concepts that you'll use, through the treaties, and through more general principles. Did Sergei explain the general principles of international law, Article 38(1)(c)? So through things like pacta sunt servanda, through state sovereignty, through equity, through all these kinds of concepts, you can kind of lead the court to say, if you believe all these legal rules work in this way and we follow this principle, then this is the only possible policy outcome we could have. We'll talk about that more tomorrow, but it's a delicate balance. If you give too much policy, it can look like you don't understand the law. And if you just give law, then that can be unconvincing. It can just be you saying, you sound like a formalist. You're just saying, this treaty exists, so this must be the law. And if you stand up and say that in front of a judge in the oral rounds, the first thing they'll say to you, so for example, with drone strikes, if you stand up and say, the law clearly prohibits the use of force, or not the use of force, it clearly prohibits the killing of civilians, let's use a more contextual question, and you stand up and say, it clearly prohibits it, the first question a judge will ask is, well, why does the US kill civilians every day with drone strikes? Are they in violation of international law? And it's very hard to answer that question unless you have the kind of policy steps that will lead you to the conclusion you need to get to. I feel like there's a third thing I want to talk about, but it's slipped from my mind now. If it comes to me, I'll come back to it. That's a nice segue into what happens when you submit your memorials. Your memorials are due at the end of January. Your national rounds will be, I think they were in late February last year. So you have around a month and a half to maybe even 2 months to move your arguments. Obviously the memorials are useful to check the law that you've argued and things, but once the memorial is submitted, it is essentially dead to you. The score will affect your performance later on, but you're not bound by your memorial arguments, so the judge can ask what your memorial says, but it can't, or can direct you to a page of your memorial where you have a certain argument, but they can't bind you to it. They can't say, you argued this here, and now you're arguing something different. That's fine. You can just say, yes, I am arguing something different, and they can't mark you down on that. Similarly, your opponent, often applicants will stand up and say, my learned counsel on the other side, they have said this in the memorial. It's totally fine for the respondent to stand up and say, we no longer argue that, or we want to focus on something else. It's also worth thinking that the memorials are dead to you because there are probably mistakes in them. No matter how deep your research has been, once you start trying to plead orally, you'll realize that there are just layers that you've missed, and particularly between the national rounds and the international rounds, if you qualify, there will be things that a judge will throw up or an opponent will throw up that you've not seen, and you'll need to research it and you'll need to bring that into your own argument. So don't be hung up that something is in your memorial. The third reason that you should treat your memorial as sort of dead to you is that functionally it's not, you can't stand up and recite your memorial in oral rounds. Your memorial is about 40 pages long, and you have at most, let's say 25 minutes to plead your case. You won't be able to read it all. You also won't want to read it all. There will be arguments in the memorial that are legally correct and need to be there to show that you've identified the issue, but they might not be the strong arguments that you want to plead in the minimum time. So for example, when we had when I had the breakdown of the roadmap before, there was at least 4 subsubmissions of international law. There was human rights law, humanitarian law, territorial sovereignty, and the use of force. But the use of force argument might not be that strong. It might not be that interesting. I mean, some legal issues are just more interesting to talk about, and you might not want to focus on them. So when you start preparing your oral arguments, it's good to think about what the main beats of the story are that you need to hit, and what the most important issues are that you need to discuss before the bench. So these are sort of 5 things that you can do in the time. You can prioritize the arguments that you have. You can polish those arguments so you can make them more convincing. You can add more facts to them. And here's the other thing. As you cut arguments, you can also expand on other arguments. So where you might have said before, paragraph 33 clearly shows that this thing happened. When you get to the oral rounds, you might want to explain how paragraph 33 is actually part of a larger story of mistreatment of the ethnic population stretching all the way back to the 1900s, and you can trace that story and kind of lead the judge to the way that you want to use the facts in the end, in a way that you just can't do when you write something down. It also just doesn't, there's something different about how language works when you write it down compared to how you speak it. So you'll end up polishing and changing parts of the pleadings themselves. You'll also want to re-research issues as you start to work out how the issues all fit together. You'll need to find new questions. One of the things that you often don't need to consider in the written stage, but is important at the oral stage, are things like the ICJ's own, the rules kind of governing how the ICJ works. Things like, is the ICJ bound by its previous case law? It's quite a common question at the oral rounds. You don't need to discuss that in the written, but at the oral someone will ask you, okay, so you're citing Nicaragua, but can this court depart from Nicaragua? And you have to have the answer for that. So there are things that are things like burden of proof and standard of proof. They can be useful to throw into the written memorial, but they're kind of hard to make big arguments on their own. But when you're actually standing in front of a judge and you have an opponent who's arguing the exact opposite from you, the judge might ask you, well, who has the burden of proof? Who has to substantiate the claim? What is the level of proof that we need to find a violation? These are things that don't come up in the written, but will often come up in the oral rounds. You'll also want to restructure your argument. We'll talk about this more when we go into the bench's questions, but it can be useful to break your argument down, not into the roadmap is useful for understanding how you conceptualize the case, and you'll want to still roadmap, you'll still want to explain to the judge, I'm going to talk about these events and how these violate these rules, and these rules have subsections. But you also want to understand how your argument can be rearranged on the fly. So if a judge starts asking a question about a later issue, you need to understand that you're moving to a different part of your argument and what has or hasn't been substantiated yet, and how to argue that convincingly and still be able to get back to the argument you were making. How to keep some semblance of structure even as the judges or the opponent are pulling you in a totally different direction. Our head coach in Helsinki, Ukri, likes to talk of the big balls of an argument. You have two big balls, and you need to juggle the balls and be able to move between them. Vivid imagery. So the more that you can start to work out how all your arguments fit together, how they rely on one another, and how you can move around them, that's crucial to succeeding at the oral arguments. So it can be useful. For example, when I started preparing my oral round arguments, drew like a decision tree. So this is the first issue, and then there are these issues, and here are where the events overlap, and here are where the law overlaps, so that I could understand, okay, so I'm relying on this treaty twice, so I need to make sure it's established. Regardless of which submission I get to first, it needs to be established properly. And then, improve. You can just improve your arguments as you go through. We'll kind of try and break these down as we go through, so I think there's more structure on them. Narrative is one of the easiest ways to be successful at the oral rounds, particularly if you're the applicant. The applicant is the first person who gets to speak, and the applicant gets to set out what the case is. Obviously, the judges have read the compromis. Obviously, the judges have a knowledge of what's going on. But if you're the applicant, you really get to set out how the facts are characterized, and the respondent will have to answer them. So if you do a good job, for example, of showing that the respondent clearly mistreated their ethnic population, keep focusing on this one because it's a good example. If you can convincingly show that argument, the respondent now has to unpick all of that work before they can even make their own legal arguments. They now have to show that they're good people, or that abuse was not illegal, which is another issue. But you really want to make it, the other point is that 20 minutes is a long time to talk to someone about a conceptual issue, about a case that doesn't really exist, and that you have to think through all the steps of and understand how all the facts intersect with the law. If you can explain to a judge exactly how that story goes and where each legal rule attaches to the facts, it just makes it much easier for a judge not only to follow you, but for you to lead them to the conclusion that you want. So you say there's this fact and this fact and this fact, and therefore clearly there's been a violation. If you can get that narrative to work, that's really good. As we're saying, sometimes judges will ask the first applicant to summarize the facts. It's always worth just having a prepared statement of less than a minute of exactly what the case is about. But other people can give the facts as well. I was respondent 1, and I had to there was a transition between an argument about use of force and an argument about annexation. And I would have a bit where, when I moved off from submission 1, I would say, if the court would allow me, I would like to remind them of the facts that led up to the annexation. And I went through all the things of the riots, the human rights violations, all the bad things, and characterize this narrative of exactly what happened. And then you could say, so therefore, in conclusion, the annexation was on the basis of all of this mistreatment before. And in doing that, it meant that the judges couldn't drag me away from the factual story. The facts had led to the legal conclusion, and then we could talk about exactly how the law fit the narrative. But the narrative was out there. If you start with the legal rule, sometimes there's a habit that you get dragged away and you don't get to the facts that are really crucial to kind of, if it's, gross human rights violations, that was the case in annexation. If you start talking about what gross human rights violations are in abstract, you don't have time to get to when these actually occurred in the case. Whereas if you set out all the human rights violations first, then the judges at least know that, it's at least out in the open, and then you're just talking about how the law fits with that. So narratives are really, really powerful tool to structure and guide the bench to the conclusion that you need. As I said, arguments need to be more fluid. Under questioning from judges, it's not the same as memorial. You can't just set your argument out. You need to be able to move around with what the interests of the bench are. Some of them will like human rights, some of them will like the law of the sea. You need to be able to tailor your pleading to what they think are the most interesting issues. Pardon me. The last point, and this isn't a hard and fast rule, but there's a slightly different, in my eyes anyway, a slightly different role that each side plays. I say applicant and respondent, but actually it's more about who is alleging the violation and who is defending the violation. So in some cases, the applicant has also done bad things and the applicant needs to defend those. But normally I think it's good if the applicant appears to be, what you imagine an international lawyer to be, like going out and solving injustice and bringing, evil states to responsibility. And it can be useful to kind of have that mindset that you are on the side of right. With the respondent, it's normally better to play the card of, this is where the legal rule was, and we came right up, but we didn't cross it. Because if you say that, then you can say, and we'll talk about this a lot more tomorrow, if international law is supposed to be based on consent, if it's supposed to be based on law that states have consented to create between themselves, states shouldn't be held accountable for things that were not illegal at the time they happened. And I think if the respondent keeps that in their mind as how they're structuring the narrative, it's useful to say, the threshold for what a use of force is, for example, is very high for a reason. Because if you find that a state has used force, that's like a fundamental rule of international law, that's what we've had since the United Nations, it's to prevent World War II, blah, 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 blah. And we came right up, but we know what the use of force is. We know that the use of force is important, and we did not cross that line. And you can't hold states accountable. You shouldn't lower the threshold because that would risk delegitimizing the international order or whatever kind of argument you want to make. And you shouldn't say that we're worse than that because we're not. So therefore, you have to let us off. It's not a hard and fast rule. Sometimes you can see very angry respondents who are very clear that they were in the right, and that can work. But I think normally because of the way that the case is written and how ambiguous it is, you probably have done something wrong. It might not be illegal, but you've done something wrong, and it can be useful to work out how to walk that line convincingly. So if we go to the next slide. Does anyone know who this is? Automatic A, if someone knows who this is. I love asking this. It shows my age, I guess, even though I'm also too young for this. This is David Byrne. He's a singer in Talking Heads. This is a screenshot from one of the best live music films ever made, called Stop Making Sense. He wrote a book, this does have a point. He wrote a book called How Music Works, which is brilliant. He talks about a whole number of things about how music is designed for the audience and the room that it's performed in. But at one point he talks about the idea of performance. And he says that, I realize there is a lot of unacknowledged theatre forms going on around. Our lives are filled with performances that have been so woven into our daily routines, the official and performative aspect has slipped into invisibility. PowerPoint presentations are a kind of theatre. I always think this is worrying to put in a PowerPoint presentation. PowerPoint presentations are a kind of theatre, a kind of augmented stand-up. Too often it's a boring and tedious genre, and audiences are subjected to the bad as well as the good. Being an international lawyer is a performance. I'm sure that you all have a picture in your head of what an international lawyer is, what they do, what their role is. And that's what mooting is, that you're getting to perform that kind of theatre. So the more engaging you can be, the more that you can live and fulfill that role, the more confidence you can bring to that role, the easier the oral rounds get for you. If you can go to the next slide, I think we have, okay, it's not here yet. There's a discussion later on about rituals. I think it's quite important before rounds to kind of establish a ritual of how you get into the mindset. I mean, even just putting on the suit was a big thing for me. When I had the suit on and the folder with all the cases, and we all had suits on, the team would walk down and you'd walk in, and and the whole of the Jessup is ritualized. The bench come in, the bench all sit, the bench often glare at you as if they're like proper, serious international lawyers. And then the second that, you'll often see this in rounds, that the bench will be really harsh and not angry, but kind of, stern looking. And then they'll send the teams out, they'll do the scoring, and then they'll come back in and the judges are all smiling and they're happy and they're, oh, well done, like you did. But they weren't that nice to you when they were on the bench. The whole thing is a performance. So the more you can learn to embody the role that you're playing as the representative of your state, the easier this all gets. There's one other thing to talk about with oral rounds that do not exist in the memorial, and that's the question of rebuttals. So I think it's on the next slide. There's each team has 45 minutes, and you divide that between the two speakers, but you also have to leave time for a rebuttal. So essentially, the applicant will speak for 45 minutes, or 40-ish minutes, however long they leave. Then the respondent will speak for their allotted amount of time, and then the applicant is allowed to stand up and speak for, I think, up to 5 minutes, but you get to pick how much time you've left yourself, and you declare that at the start of the round, how much time you want for the rebuttal. And the applicant gets to stand up and get one final crack to respond to the respondent and set their case out. And then the respondent has to stand up immediately after that and give a rebuttal to the rebuttal. That probably sounds really difficult right now, particularly for the respondent. It's something that scares a lot of people, being the person who's in charge of the rebuttal for the respondent. Like, the idea that you have to stand up and respond to what someone has said 30 seconds ago fills a lot of people with fear. I have been the rebuttal person for respondent twice. Once you learn how to do it, it's great fun. And it's actually probably the easiest way to win a round as respondent if you can do the rebuttal well. You can practice a lot of it. In your teams, you can have scorecards written out of rebuttals where you basically we would do a kind of carousel. So the applicant would stand up and say 2 points in rebuttal, this and this, and the respondent would have to get up and respond to that. And the applicant would get up and say 2 different points in rebuttal, and the respondent would get up and do the same. You would do that for 20 minutes. There's only a limited number of points that will come up in the rebuttal. There are certain big issues in the case that, unless you're against a team who hasn't understood the case properly, and that's actually the worst team to do rebuttals to, because then you can't plan for it. But if it's a good team, there's only a few big issues they're going to want to hit, or there'll be weak points in your case that you know are there and they're going to want to hit them. So you can practice how to respond to those. The other thing you can do, and this comes back to the point about policy that we were talking about earlier, is think about the bigger picture of the case. It can be useful for your rebuttal to say, not only did the applicant or the respondent make these mistakes or misidentified this case or misunderstood this case, but if we follow their reasoning, then this terrible outcome would happen. So, for example, in our case, when I competed, there was something about whether a treaty was invalid, had been voided. And we had this, my sub-rebuttal point was that that there's this principle of pacta sunt servanda, that treaties bind and that they are there. You can make any argument about the treaty come back to pacta sunt servanda. It doesn't matter what bit of the treaty the applicant wanted to pick up on, what bit they thought was wrong, what case you thought they got wrong. You stand up, you respond to it in 10 seconds, and then you say, you know, Your Excellencies, if we follow the applicant's reasoning, you know, we would be violating, we could invalidate half the treaties around the world. I mean, you don't want to be quite that theatrical, but half the treaties around the world, and therefore, following the basic fundamental cornerstone principle of pacta sunt servanda, you must rule in a judge and declare in line with the respondent's reasoning. Yeah, and in fact, I had a little closing line which I stole from a advert for a law firm in Copenhagen Airport, which was that the last line was problems are complicated, solutions are simple. Your Excellencies, you must rule in favour of blah 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 blah. I've heard stories of at Telders, there was a guy who apparently he had little like Harry Potter glasses, and he was doing the respondent rebuttal, and he stood up and, you know, responded to the 2 points the applicant had made, and then he took his glasses off kind of dramatically and folded them and went like that and went, Your Excellencies, you know, proper CSI acting. So I mean, I think that's ridiculous, but there's ways you can get the markers of the rebuttal down long before you need to do it. This is the other mantra: sniper shots, not machine gun fire. You'll see some teams get up and they will dedicate 5 minutes to rebuttal, and they will fire 10 points at the respondent, and they'll say the respondent got this case wrong and this case, and they don't rehash your arguments in the rebuttal. The judges don't need to hear them again. What you need to do is find the things that are devastating to the other team's case. So also don't nitpick, don't stand up and say, oh, they said paragraph 33, but actually it's paragraph 32. Nobody cares. You need to find the kind of holes in their armour that take their entire case down. So that's why I suggest, 2 to 3 minutes for applicant, and I would say 2 minutes. You can go as low as 1 for 2 for respondent, because you just need to hit these points. There's no need to do a huge explanation. The applicant needs a little bit more time because they have to respond to a full 45 minutes of respondent pleadings that they haven't had a chance to respond to. But the applicant only needs to, at most, there should only be 3 points in rebuttal that the respondent needs to answer. But some teams don't follow that, and your coach may have a different perspective on this, so by all means, don't listen to this. This is just the way that Helsinki's always run it. It's the way that I've seen most good teams run it. It's the way that most final round teams run it. And I think as a judge, it's much easier if someone stands up and says, this is the big picture, these are the points, here's how the other side is wrong, and here's how our outcome is correct. That is, you know, the sort of perfect way of doing the rebuttal. If we go to the next slide. So structure of the oral rounds: bench of 3 judges, each team has 45 minutes to plead. You will have 4 rounds, 2 as applicant, 2 as respondent. The way that is graded, and I went to check on this last night. So firstly, the judges will decide a winner and a loser, and that's your win-loss score. So at the end of the 4 rounds, everyone will have a score out of 4 of the number of rounds that they've won and lost. There's no draws for the oral rounds because there's 3 benches, there's 3 judges, so there's always going to be 2 judges who think one team has won. So what happens is that all the teams get ranked by their win-loss score. And for example, in DC, there's normally, I think, around 14, 15 teams that have 4-0. And then the next level of the grading is what's called round points. So the judges will each vote for which team they think has won. And so if 2 judges vote differently, then the teams will each get round points. Does that make sense? So even the losing team, if they lose by a 2-1, will get round points. But your memorial scores also come in here. So your memorial scores are compared to your opponent's memorial scores, and round points are also worked out from them. I think there's a heavier weighting towards the oral rounds. I'm struggling to remember now. I think the oral rounds are worth 50% more than the memorial scores. But either way, you can still pick up round points. Even if all three judges think that your opponent was better, but your written memorial was better, you can scrape round points back. So after the 4-0 win-loss, you then have all the people who were 3-1, and they'll be ranked by round points. And normally that gets you to around, I think in the international rounds, around 29 teams will now have been assigned by that. Then it comes down to raw points, and the raw points are the basis of what the actual number was that was given to your memorial and your oral scores, and they're added up into a total. So that's where it comes down to actual. It can be 2-3 points can be the difference between being in the top 32 and not being in the top 32. So that's where the penalties and things become really important. After that, the quarter, semi, and finals, they are not, the memorials cease to matter, and it's just a win-loss. There's no scoring. They can write a score sheet to give feedback, but it's just a winner and a loser. If we go to the next slide, I think there actually are score sheets. So this is the oral round score sheet. Here they do actually ask the judges to follow a certain scoring system. And if we go to the next slide, on the back there's comments for each oralist that the judges can choose to fill out. The judges also have to sign the form, which means that when you're at the after party of the competition, all of the coaches can come up and berate you as a judge for getting for grading their star pupil so low. I say that with love, obviously, and having been the coach who's been doing that as well. So you can identify which judges you won the round from after the score sheets have been released. If we go to the next slide. So this is how the oral rounds are divided up, and you'll see here that unlike the written suggestions, the score sheets are not, the score weighting is not equally balanced. So the knowledge of the law is the most important thing. Questions and answers is next. Oh, they're actually in order. I never noticed that. Questions and answers is next important. Knowledge of the facts, style, poise, and demeanour, and then organisation and time management is the last issue. In practice, those are not as watertight as you would think. Often, well, first of all, actually, many judges don't even bother with this. Some judges just write their total score. They just have a sense that the speaker was a 79, and they just write that down. You have a sense of what the person is, or if they're above 90, that's kind of exceptional. So you have an idea if they're 93 or 94, 95. What I think most judges do is they have an idea of what the number is, and then they try and make the maths add up to that. But what you'll notice is that the questions and answers and the style, poise, and demeanour and the time management are worth 50% of the case, of the scoring, sorry. And that has nothing to do with whether the legal arguments are actually good. That just means that you can stand up. I mean, style, poise, and demeanour just means that you stand and you speak confidently and you speak slowly and they can understand you. Questions and answers just shows that you can respond comfortably to the judges. So there's a weighting in benefit of being a good speaker over necessarily the content of the legal arguments. And that doesn't work in practice because, for example, the quality of someone's questions and answers probably depends on them having a good knowledge of the law, because you can't really have a back and forth if your legal knowledge is bad. But it's hard. Sometimes when you start adding the numbers up, you think someone is a lower grade, and then once you've added them and you've thought about it, they actually go up in your estimation. And some judges some judges really don't care if you have the knowledge of the law, or they don't know the law themselves, so they just think it sounds correct and they give you a 25. Not to be cynical, but sometimes that happens. So, the score sheet is not an exact science. Normally, as I said, that you get the sort of good, very good, excellent, sort of 70s, 80s, 90s. That's fairly clear normally. But how they break down is different. And it's just to sort of stress that the oral rounds do require other skills than just reciting your memorial. Even if your memorial is perfect, if the knowledge is all great, if you can't stand up and speak it, then you will suffer in the score sheet. And this is why some people, divide their teams so that there's only 2 people speaking for both rounds, for both applicant and respondent, because it means there's some kind of consistency. I'm not saying I advocate for that, just that particularly teams that have competitive national rounds or just are a competitive university in general, will sometimes prioritize that, or will have speakers that are trained from researcher to being a speaker by their 5th year in university. That's just something you see sometimes. If we go to the next one. So 3 kinds of judges, or 3 kinds of benches that you can get. The helpful bench is the best bench. That's a bench that is engaged, that knows the law and wants to talk to you about why this is interesting. Or if you don't know the law and you're clearly struggling, they will at least try and help you get to where your argument needs to be. It might sound weird, you might all be quite frightened of the oral rounds right now. The idea of being questioned by judges might sound terrifying. You honestly want questions. Questions help not only structure your speech, but also help show exactly what it is the judges are looking for. So the judges might say, we know about this case law, can you explain how it applies to facts? And you know that you need to swap to that. And if you can move your speech like that, then your style, poise, and demeanor is automatically a good score. Your question and answer is automatically a good score. Your time management is probably easier if you're getting questions like that because you can jump ahead. The best is when you have a conversation. If you see a judge is really interested in an issue and really likes talking to you about it, try to drop the formality after a while. Often speakers will, when they receive a question from the judge, they'll say, "Thank you for that excellent question. If I may respond," and they kind of frame it out. If you're having a back and forth with a judge, don't be afraid to just answer them and to have a conversation about it. I mean, if you get someone, who works on drone strikes, they're going to want to talk to you about this. They think drone strikes are interesting. I know it sounds frightening right now, but we'll get to this. You'll be an expert by the time you get there. You'll probably be more of an expert than some of the judges. Definitely more of an expert than some of the judges, and possibly as much of an expert as some of the people who do this day to day. So the more academic, the more conversational, the more smooth that bench can go, the better. If we go to the next slide. This is a slightly worse kind of hot bench, an antagonistic one. So this may be where judges have a preconceived notion of the right answer of the case, or they may not like your argument, and that's particularly bad if the case is poorly written, if they just don't think the argument is right. But sometimes this can be an act. Don't be afraid to, just because a judge is being hard on you doesn't mean that you're doing badly. It might just be how they like to present themselves as a judge. If we go to the next slide, I'm aware I'm sort of pushing time. Cold bench is the worst case. That's where they sit in silence for 90 minutes, or the only question they ask you is, how is customary international law formed? What are the sources of law before the ICJ? Is that treaty in force? Yes, paragraph 30 says it is. Okay, thank you. That one is impossible to tell if you're doing well, because they will, you can't tailor your pleading. You can't tell if they think you're convincing or not. You can't tell if they have picked up on the mistake that the other team has made. And that can be the worst when you then get the feedback sheets and you've got a bad score and they say, oh, that argument didn't make sense. And they didn't question you on it at the time. You had no time to correct or explain why it was right. They just, write the score. So that's absolutely the worst kind, and hopefully you can avoid that. Okay, we'll speed through this. So, sorts of questions judges can ask you. Test your general knowledge, questions that move you around your argument. I haven't read the compromise questions, which are things like, can you explain the facts, or what is the law of the sea? Why is it relevant here? Sometimes those are good opportunities, though, to be able to explain to the judge exactly how you understand the case, how you understand the legal regime, how you understand why this is important. But sometimes they're just annoying, and particularly when they don't know the answer themselves, that can be a problem. If we go to the next slide. Good devil's advocate questions, where they'll ask about a point that the applicant might make, or what if the facts were subtly different, how would that happen? That's quite a common one. More academic questions like what exactly are human rights for? Sometimes those are traps that you'll have led yourself into. Sometimes you'll have teams stand up. Last year there was a team I saw say something about human rights, and they led themselves into a trap where they essentially said that killing 2,000 people was proportionate to some goal that was absolutely not true to. But they'd kind of been led down a road that then brought to this question. And then when you hit them with questions like what exactly are human rights for, who do they protect, they struggle to reconcile the fact that human rights protect the individual with what they'd said. And then finally, big picture questions. This is something that you'll hopefully pick up on as you get further into the case, that often something in submission 1 will connect to submission 3. So whether you win submission 1 might absolutely change the character of the factual status in submission 3. So in our case, because there was this annexation question, if we won submission 2 and we had annexed the territory, then submission 3 and 4 no longer mattered because we owned the material now. That's often something that they'll try and catch you out on, and if you can show that you know that and you can show that you can move between it, it's really good. Let's zip through this. Best practice, prioritize your arguments. Avoid a speech. It's useful to have, I don't have a photo of my notes anymore, but I would have the bullet points, the things I had to hit, and the citations and quotes in a notepad, and I would just read those. But try to avoid a speech, try to avoid lengthy quotes, try to avoid a list of every authority that you need. It can also be useful to have space. So I had an actual template where it was each submission with big gaps and the big quotations I needed. And in the gaps, I could sit and write down what the applicant had said. So if I knew that submission 1, I had to talk about use of force, and the applicant stood up and said something about use of force, and then the judge asked a question that said, well, what about this case? I could write down that had been raised. And then when I stood up, I could say, Your Excellency asked my learned colleague about Nicaragua. Allow me to challenge the characterization of that case that was given by my opponent. Here's actually what the court said. You could read the paragraph out to them. The more that you can kind of formalize your speech and be able to move with the bench and move with what your opponent says, the easier all this becomes. The more you can kind of drill your argument down to flashcards that you can then adapt and move around it just makes the whole oral thing much easier. Listen to the bench. Don't be overly, if they like you and if they're asking questions, just answer them. Don't keep being nice to them. Make sure that you're answering the judge's question. Don't avoid the question. Try and answer precisely. Don't let yourself get led into traps. Don't say something that you don't need to say, because if they'll pounce on it and they'll ask you more questions. So if you want to talk about paragraph 205 Nicaragua, just talk about that. Just set out the thing you need to set out and then move on. And make sure that you're getting through your entire speech, that it's well structured. And sometimes they're trying to help you. The judges don't hate you. Sometimes they are trying to help. If we go to the next. Preparation, practice with your team. Just practice pleading against each other, hammering each other with questions. Practice a cold bench where you have to speak for 25 minutes. Practice a hot bench where you only get questions. Try a no time limit round. That one is brutal. Just have your team ask you questions until they have no more questions to ask. Spend an hour on each submission, but you'll know exactly how far it goes, how deep your argument goes. Write down every question you can't answer. Put those in a Google Drive. Answer them by your next meeting. When you're at the international rounds or the national rounds, write down every case that's mentioned that you don't know. Have an answer for it for your next pleading. And finally, we'll skip through these because they're quick, but you can watch. Oh, and yeah, if you go to the next one, best advice yet, have a good night's sleep, have a ritual. I used to listen to like heavy metal music before going through because it would get you kind of pumped up. You're going to have a talk on speaking style, so you'll get help with that, but like breathe from your diaphragm, project your voice. These are all things that you can practice. Visualize yourself winning the case. But yeah, if we go through it, my friend gave a speech at Harvard once, I think, and she wrote on the top of all of her speech notes, "You are a warrior queen." And every time she looked at her speech, you could see that, and she would smile to herself, and she would visibly. So if you have notes like that written, that can be really helpful. And then if we go, so there's the Whiting case guide. You can basically just click through these. There's a bunch of examples of how these go. You can also watch the judge's guide to see how that. There's the final round, which you can watch, and then there's real-world pleadings that you can access online. So the ICJ, I mean, you can just skip through these. The ICJ, you can go through, honestly, just keep clicking left. You can go and see the cases, watch videos of them. You can also see the written memorials that they've submitted. There's also the Law of the Sea, the Tribunal of the Law of the Sea also has videos online. The ECHR has the same. The UK Supreme Court has the same. Some of these are quite boring. The UK Supreme Court can be dull. And then finally, this is genuinely the best preparation you can do. Does anyone know about the Doggy Supreme Court? I'm going to have to explain this really quickly. So the US Supreme Court won't let you show footage of their pleadings. They'll only put audio out. And John Oliver made a Dog Supreme Court, would put the video online and ask people to edit it together to real audio to make it interesting to watch. Find this video, Hobby Lobby versus Obamacare, Sebelius, hashtag real animals, fake paws. Apart from the fact that it's great to watch because the dogs are brilliant, the guy who's pleading is one of the best one of the best examples of oral argument I've ever heard. He's an American guy pleading before the Supreme Court. I only barely knew what Hobby Lobby was about, and his argument makes total sense. You hear the judge ask him something, he'll say, well, Your Excellency, there's actually 2 answers to that question, allow me to take you through them both. Watch the first 20 minutes, or just put it on headphones and go and do something else. It's phenomenal. Like, if you can crib anything from that guy's speaking style, the oral rounds will be so much easier for you. Yeah, okay, so what we've heard today, writing a memorial, road mapping, written arguments, oral arguments, and dealing with questions. Tomorrow we look at the big hole that's been in the middle of my pleading so far about how you actually make a persuasive argument. Does anyone have any questions? I know that was a real tour de force. I'm sorry for cutting into your lunch. Is there anything else anyone would like to ask? In general? Nope. Okay, see you tomorrow. Thank you.